District of Ohio with the Honorable Marilyn Zayas is now in session. Please be seated.
All right. Well, good morning. Welcome to the First District Court of Appeals. I hope everyone had a great week. So we have two cases that are scheduled for argument this morning. The first case that we have is State v. Scott, which is case number C210627. If attorneys can please identify themselves and their readiness to proceed.
Good morning, Jennifer Kinsley on behalf of Appellant Catherine Scott, ready to proceed this morning.
Thank you.
Joshua Loya on behalf of the appellees of Ohio, ready to proceed this time.
Thank you. And the second case we have for argument is State v. Benton, case number C210476.
Ron Springman on behalf of the state of Ohio, we're ready.
Thank you.
Good morning, Laura Peters on behalf of defendant appellee Julia Cleon, ready to proceed.
All right, thank you very much. All right. Attorney Kinsley, if you can come on forward, and would you like to reserve time?
Yes, I would like to reserve 5 minutes for rebuttal, please.
All right, you can start whenever you're ready.
May it please the court. Appellant Catherine Scott was wrongfully convicted of excessive window tint, absent sufficient evidence that her car violated the standards adopted by the Director of Public Safety for light transmittance through windows. And she was also wrongfully convicted of 2 moving violations, improper change of course and running a red light, because those convictions were based on unreliable and inconsistent testimony. To remedy these errors, this court should do 2 things. First, it should hold as a matter of first impression in the state of Ohio that to prove a violation of Ohio's excessive window tint statute, the state must present evidence of nonconformity with the light transmittance standards contained in the Ohio Administrative Code.
So is your position is that that would be the only way to be able to establish that the tinting was not proper?
Yes, there must be evidence of nonconformity with the light transmittance standards.
So how would you respond to that would be adding language to the statute?
That's not adding language to the statute. That language already exists in the Ohio Administrative Code, and the legislature has defined the crime by nonconformity with those standards. That's actually the crime that the legislature has established.
So we have to read the statute in the Ohio Administrative Code together as one.
Yes, and that's actually what the only court that has even considered tangentially this question has concluded. That's United States versus Torbert out of the Southern District of Ohio. And in that case, the court considered how these 2 pieces of legislation work together. Judge Black decided that case, and what he concluded was that the Ohio Administrative Codes actually supplied the standard that the revised code defined to be the crime. And what he concluded is that together these 2 pieces of legislation establish specific transparency percentages that a window tint must fail in order for there to be a crime. The state must present evidence.
The 6th District has also provided some language that's a little bit different than the Southern District, and that comes from Griffin. Are you familiar with that?
Yes, Your Honor.
Okay, and that court seems to be reaching for something that is more objective, using also the winting tinting measurements as one of the possible components, but leaving it open for other methodology that is more objective, and they speak specifically as to expert testimonial evidence.
Yes, there could be a variety of ways to meet these standards, including a tint meter. A tint meter is just one of the ways that the state could meet this standard. But mere human observation is insufficient. Just the naked eye cannot discern just in the same way that the naked human eye could not discern the weight of a quantity of drugs, for example. The statute is embodying a quantity of measurement, and there must be some testimony presented by the state as to this quantity of measurement. And in this case, there simply was none. There was no testimony about the measurement of light passing through these windows. There was only testimony about sight lines, not any testimony about light percentages passing through the windows.
Was there any testimony with regard to training of the officers with regard to this issue?
Absolutely not. The only testimony that the state procured was with regard to the officers' vision levels, whether they had 20/20 vision or if they needed any kind of corrective lenses to, address their vision.
So if hypothetically we were to agree with you, wouldn't it be sufficient for us to say that given the evidence that was submitted that was not proper or was not sufficient?
Yes, this court could go one of two ways. It could indicate that the evidence presented in this case was insufficient to meet the state's burden. But I would encourage the court to go a step further because there are systemic barriers to people appealing excessive window tint convictions. The fine that is levied for this particular offense is cheaper than it costs to actually appeal the offense. And so it's very rare that a person would come before this court appealing this kind of conviction. And thus, it's very rare that a court like this one would have the opportunity to clarify the burden of proof, which is why this case is one of first impression and may be one of the only opportunities that an appellate court will have in Ohio to explain the state's burden of proof. Compare that against the thousands and thousands and thousands of excessive window tint citations that are issued across the state every year.
But we don't have that in our record, these thousands and thousands.
There is evidence in the record. The trial court cited a study indicating that 5,200 citations were issued in Franklin County in 1 year alone for this particular offense. So there is a data point indicating that many, many people are being cited for this. We don't know if those were right or wrong.
But that's the issue. I mean, what you're asking us to do in this case, this is going to the sufficiency of the evidence for a conviction versus probable cause to pull somebody over. So all of these citations, I mean, this is not going to do anything for police are going to be able to pull people over anytime they think that the window tinting is excessive, right?
That's right. And that standard's already clarified quite in a quite detailed way in the law. But what's not clarified is what the state is required to prove to convict someone. There is indication that some well-functioning police departments, including the Hamilton County Sheriff's Office, are already using tint meters. This court in 2017 decided a case Sims, which indicates that the Hamilton County Sheriff's Office is making use of tint meters.
Ms. Kinsley, just to clarify, so you're saying that a police officer's vision is sufficient to make a stop, but not to support a conviction, correct?
Case law has already indicated that a police officer can make a visual inspection, and that's sufficient for reasonable suspicion that windows may be in violation of the statute. But that does not, just in the same way that someone may smell marijuana, and that might create reasonable suspicion to stop a person. Smelling marijuana is insufficient to justify a conviction that someone was possessing marijuana. We need to actually test the substance that's found on the person to verify that it is actually marijuana in order for the state to meet its burden of proof in that case. It's the same framework here.
So the testimony in this case was simply that the police officer could not see through the window into the car.
Correct.
That's all we had.
Correct. Yes, there was no testimony as to light transmittance at all.
Now, there was other evidence with regard to light transmittance, wasn't there?
No, there was no testimony as to light
Not
transmittance.
testimony, but that evidence. Wasn't there the video cam?
There is a body-worn camera that shows the car, but that evidence doesn't contain any discussion of light transmittance, any testimony regarding how much light is going through. If we were to watch that body-worn camera, we would be making the same kind of visual sight inspection that the officers made with our untrained eyes and our vision the way that it is as, being human beings. We don't have any particular scientific training on how to look through windows.
So is it your position that there's no circumstance in which a human could look at a car and determine whether there's a violation of the tint statute?
That's correct, Your Honor. Turning to the other two traffic...
Let me make sure I understood that. So even with training, that would not be possible? Is that your position?
I suppose in some hypothetical circumstance, there may be some very well-trained expert who has the capability to look at certain qualities of a particular window. I'm not familiar with any scientific discipline that would meet that standard. I suppose one could exist. Certainly, it was not presented in this case.
And I think that brings me back to the Sixth Circuit case where the language in there goes beyond the tint meter as something that's more objective, and I'm going to add a word, reliable. So they left it open to go beyond the tint meter.
Yes, if science could develop such a discipline or test, I suppose at that point, courts have mechanisms for ascertaining whether it's reliable, and using the court's gatekeeping functions, the court could determine at that point if that was sufficient. Turning to the other two traffic convictions, I just want to highlight for a minute how unreliable that testimony was.
And counsel, I'm going to give you 30 seconds. I know we've asked you.
Sure. There was only one officer who saw these moving violations. He changed his testimony as to the make of the car, the street that he was driving on. He never saw the driver, so he could not identify Ms. Scott as the person who committed these alleged offenses.
But didn't he testify that the car that his fellow officers had stopped was the same car that he had seen committing the violations?
He did say that, but I think that point is unreliable in light of his other mistakes and errors in his testimony. What's worse, he couldn't even identify his own handwriting. And I think that really undermines the validity of that identification that he made. Thank you, Your Honors.
Thank you. Good morning.
Good morning, Your Honors. We would like to reserve a bit of time to Your Honor.
And, well, do you have a cross appeal?
I'm sorry, Your Honor. No, we would not. My mistake.
Okay, that's fine.
Well, at any rate, Your Honor, just kind of getting started on this, we would be asking you to uphold and keep the decisions by the trial court in this matter for these two traffic tickets. As was stated earlier, one of the initial stops was because of the window tint. And while there was no tint meter presented at the time, the statute itself indicates that its primary purpose is that a person of normal vision can look through the windows and tell what's inside.
So are you saying that the statute and the administrative rule should not be read together?
Your Honor, I believe the statute itself can be read on its own, but I believe both and the administrative code, its purpose as well, says the same thing. The very first thing, what the first thing it says, a person of normal vision can look through this window and therefore see what's inside. If they cannot do that, they are in violation. I believe that what happens afterwards is simply a way of adding a kind of I guess just average kind of what they would do if they were to do light tint. That said, this is different than Griffin in the sense that in Griffin there was only one officer who testified at that point. We have three different officers of three varying vision abilities. We had the lieutenant who said that he had less than normal vision, but had glasses to correct that. We had another officer who said he had 20/20 vision of a normal average vision, and we had an officer who said he had above average vision. All three of them together looked at that window and said we could not see through that window tint.
So it's completely subjective, though. I mean, this is don't you find that kind of problematic to convict somebody on evidence that is that subjective?
I believe in this case I would not, as opposed to three individuals can look at something and identify it. The three of you can look at that and tell me that glass holding water is transparent. Three individuals
But
can.
we can't necessarily look at a piece of glass and say the percentage of light is this.
You cannot look at that and give an exact percentage, but you can look at that and say that a person cannot look through this. A person of normal vision could not look through that window and tell you what was inside of it.
So let me make sure that I'm understanding your position. Are you saying that the test is vision rather than light?
I believe.
Because there is a difference.
Your Honor, I do believe that the primary purpose lays out a test that says normal vision. That normal vision is what the primary purpose is. So I would say that if a person with normal vision cannot look through it and sit there and say, I can't see through it, that person is in violation of window tint.
So you want us to basically ignore the administrative code, even though the statute itself says the Director of Public Safety shall adopt rules governing the use of tinted glass. You want us to completely ignore the administrative code.
I would not say ignore. I believe that that's also more of an advisory because there are other code sections of the Rice Code that have accompanied administrative codes that are similar and lay out similar, and also lay out that there are similar levels, such as possession of drugs, OVIs. They all lay out that they have to hit specific numbers of, alcohol inebriation, amount of alcohol in urine, in breath. They lay out amount of drugs in the bloodstream, amount for drugs to reach different levels of the crime. And each of those OACs, they specifically identify what material, what items must be used, what equipment should be brought out, what labs must be used. In each one of those, that is the step that must be taken. In this particular OAC, there is nothing. It is silent. It says it gives percentages, but it gives no method. It gives no equipment. It doesn't say anything about tint meter. It just says.
Why does it have to give equipment, though? I mean, if it's giving a light percentage, then I would assume that in order to prove that, you figure out what equipment you need. Why does the administrative code have to put out the equipment?
Your Honor, I believe it would have to put the equipment because that would help satisfy what is necessary for them to prove it. And especially since, again, this comes back to the primary purpose of it is to present it, to allow a person of normal vision to see through the car windows. That was the purpose of both the OAC and the ORC. I think that the percentage simply adds to it and allows for it. But I believe if a person of normal vision cannot look through a window, especially in this case, we have three different officers with normal vision, three officers of varying visions, could not look through that window and tell you it was that they could see through it. I believe that is a step that could be said that would be sufficient enough to find somebody guilty on it.
So let me ask this. Let's say that, the three of us looked at the video, and if we could see who was in it, would that make a difference?
Your Honor, I believe that would be a thing for the trial court. I believe if the three of you, or if the judge itself was looking through the window, looking through the video and said, I can see through the video, I'm looking at this window tint, I can see through on the video, then that judge could possibly have reason to find that person not guilty. But in this case, that was not the case. The video was presented, the judge did not rule in their favor.
So back to what Judge Krause was saying, doesn't that make it a very subjective test, though?
No. Your Honor, I don't believe it is exactly that subjective. We use a normal person standard for a lot of things, and I believe the other thing to realize is that we have an actual number for a normal person here, a 20/20 vision. We have an officer with 20/20 vision. That itself should be sufficient. Furthermore, I believe that these officers, to go back to the Griffin as well, the officers do have quite a bit of training. One was a lieutenant. They have experience doing this. One was a lieutenant. The others were officers as well. They have been with the force for some time. I believe that all three of them have, in their time, look at these situations, and I believe that would be possibly the only kind of training they would receive in this matter. As looking at something and say, we can't see through this. Maybe there was a time when they used a window tint and eventually you use it enough times, say, yeah, that's going to be where it is.
I want to clarify one of your responses, and it goes back to at the onset of your argument, you talked about these three officers, their varying level of ability to see and correction of that ability to see, and you used a pitcher of water as an example.
Yes, Your Honor.
So going back to Judge Bach's question, if you have three appellate judges that review that video and hypothetically are all able to see through the window into the internal compartment of the vehicle, wouldn't that raise enough for sufficiency? Because although, as you said, the trial court, had their own determination. What we have before us is sufficiency.
I understand that, Your Honor. I believe if that was the case, if you were to review the evidence as well to see if there was sufficiency in that matter, I believe it's possible, yes, if you could look through the window and tell that this is something that you could see through it and identify what was inside, that may actually raise up to being sufficient enough to say that that person was not guilty of it.
All right, thank you.
All right, no problem, Your Honor. All right. Now, moving on from that, like I always say before, Your Honor, there were additional charges as well. As was stated earlier, she was also found guilty of improper change of course and running a red light. These were witnessed by the lieutenant who was in an undercover vehicle. While he did not see the driver inside the vehicle, he was able to identify it as a white car. While he might have gotten confused about the make and the model, he was still able to pull up to the car that was pulled over and says, yes, that is the vehicle I saw. The defendant herself even identified that I was the driver of that vehicle in her testimony. So the other officers identified her. She identified herself as the driver, and that officer confirmed to the other officers before at the onset of the stop that this is the vehicle I was at you all stop. I believe that on its own is sufficient. It would be sufficient enough to say that those other crimes should be upheld as well. Yours? Right. And yours?
Yeah.
Lee?
I mean, would you say that the other charges turn on credibility of the witnesses?
I believe it turns on the credibility of the witnesses as well, Your Honor. But I believe that the trial court, as far as the manifest weight goes, the trial court heard all the witnesses as well as the defendant herself got the opportunity to get up and testify in her own defense. The trial court got to hear her and was able to weigh all the credibility of the witnesses in front of them and decided that the officer's testimony was the more credible at the time.
Thank you. Did you have anything further?
No, Your Honor. I would just be asking you at this point in time to affirm the decision of the trial court, Your Honor.
Okay, thank you. Thank you for your argument.
In response, looking at the statute itself, RC 4513.241, there is only one substantive restriction on an individual's conduct, and that is found in subsection F, which indicates that no reflectorized material shall be permitted on windows. Other than that section, there is no absolute restriction on what kind of tinting an individual may put on their windows. Instead, the statute delegates that kind of rulemaking to the Director of Public Safety, and then indicates in various subsections that violation of the standards created by the Director constitutes a crime. In other words, a crime does not exist unless the windows are in violation of the OAC.
Which is all governed by light transmittance.
Absolutely, Your Honor. So the OAC is what defines the state's burden of proof. And those light transmittance standards are critical to the definition of excessive window tint. There cannot be a crime without those standards. And in this case, I think we've gone over this quite a bit. There was just no testimony about those standards. In addition, with regard to the moving violations.
Well, I think the state would say that the testimony was, we can't see through the window.
And that's testimony about sight, not testimony about light. These are fundamentally different things. Turning to the moving violations and the testimony about the car. There was very conflicting testimony given by the one officer, Lieutenant Schofield, who was the only person who claimed to have observed these moving violations. First, he called it a Kia, then he called it a Hyundai. First, he said it was on Vine Street, then he said it was on Race Street. He could not identify his own handwriting on two separate documents, including the original.
Aren't you really making a manifest weight argument here?
Yes,
This
you're
is not
right.
a sufficiency argument.
Yes,
Okay.
it's a manifest weight argument. Critically, despite being trained to look for guns and gang members being a lieutenant in this special task force and being highly concerned that this car he saw was fleeing a crime scene, he never mentioned a critical aspect of Catherine's car, which was a temporary tag, something any officer would have definitely noticed if he really saw her car. She testified that she was coming from the other direction. She was never on Vine Street or Ray Street. Many people have white sedans. This was simply a mix-up. She was not the person driving the car that Lieutenant Schofield saw. He lost sight of it, and by the time the other officers surrounded her, this was a case of mistaken identity. They got the wrong car. We would ask your honors to reverse all three of these convictions. Thank you.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision, and we wish you both a wonderful afternoon.
Thank you.
Thank you. State v. Benton. Good morning.
Oh, good morning. Thank you, Your Honor.
How are you doing?
I'm good, thank you. How are you? Ron Springman on behalf of the state. This is straightforward. I guess this seems to be a series of cases involving pre-indictment delay. And so in this particular case, we're talking about a misdemeanor domestic violence and the delay between when the arrest warrant and the investigation were initiated and the defendant was ultimately apprehended was slightly over 6 months. And the trial court made a finding, and of course the controlling case on this, we're all probably very familiar with, Barker versus Wingo. You know, the first factor in pre-indictment delay is length of delay. But under that factor, we have to look at the case law says that there's a certain time limit where the delay is presumed to be prejudicial. And if you go beyond that presumption of prejudicial delay, whatever that time frame is, then you do not analyze the other three Barker versus Wingo factors, reason for the delay, the assertion of the right, and demonstrable prejudice. So here we have a finding by the trial court that is consistent with this court's opinions, that we cannot presume that the length of the delay, which was about 6 months, is prejudicial. So this court in 3 cases, starting with State versus Sears, but I'll begin with State versus Mohamedel, paragraph 14, that cites the State versus Sears. This court has set the presumption of prejudicial delay for a misdemeanor assault case at 9 months, or at least 2 months, nearly 3 months prior to reaching that point of
Counsel,
prejudicial delay.
is it your position that 9 months is a hard stop? And
That sounds like the position of this court and the
what about the
cases.
Mugney case?
I mean, that it does suggest there is some wiggle room, but here's the issue and why I think it's nice to have some bright line rule on this. And 9 months seems to be a reasonable amount of time because police departments have a plethora of cases. Emergency room departments and hospitals have a plethora of cases, and you're triaging. You know, you don't know, and I don't think courts want to micromanage what police focus on constantly, but you have to set a limit. They just can't ignore a case for a certain period of time, and it seems like the general limit is about 9 months for a misdemeanor case. And the courts have been pretty clear that if it is less than 9 months, before you get into analysis of the other Barker versus Wingo test, you do have to have a presumption of prejudice. And we have
But
two
we
things
actually
going
have
on.
prejudice in this case, right? Because evidence was destroyed in the meantime.
Well, that's open for, well, we don't get to that factor, but let's say we do, okay? We don't think we do because it's only been 6 months. But yes, there could be that issue that if this case continues on, was it bad faith or not bad faith? But look at the probative value of that. They had body cam, but none of the officers witnessed the incident. They were called to the incident, and they took a statement from the victim. They were able to corroborate that there was a picture frame and glass was broken. So the actual incident wouldn't have been caught on the body cam footage, and it would be up, first of all, for the trial judge to determine whether or not the state acted in bad faith, whether or not there was a motion to preserve that video evidence if this case is returned. That would all have to be flushed out, right?
Well, how could there be a motion to preserve if the defendant didn't even know about the indictment?
Yes, exactly. So, we didn't get there yet. So we're at a point now where, it was only 6 months. And
So we don't even care about speedy trial if it's 6 months or less, because we don't get into any of this other.
the prevailing case
Stuff.
law seems to certainly suggest that. It's,
Right.
all the cases I cited, that is a triggering mechanism. If you go beyond, at least in this district, it said 9 months. If you're beyond 9 months, that's a triggering mechanism that requires the trial court to engage in an analysis of the remaining 3 Barker versus Wingo factors.
Attorney Springman?
Yes.
Would you like to reserve time?
Oh, thank you. Yeah, I would reserve a couple, 2 minutes. Yeah.
Okay.
Am I close to that already? I didn't know, but
No, I just didn't want to interrupt the flow.
no, I just think that police departments and as prosecutors that advise police departments, it's nice, and I know courts we like to give them bright line rules, and I thought 6 months seems to be, or 9 months that this court set seems to be fair for a misdemeanor. It
Well, we
allows some
we
predictability.
declined to do that in Mugney. Are you saying that we should change our minds here and do that in this
Well,
case?
I'm asking the court to follow Sears, Mohamedel, and Duncan.
I don't think any of those cases said that there's a bright line rule.
Well, they said in this district, 9 months is basically the length of the delay inquiry serves as a threshold inquiry. In this appellate district, this is a first district case, I'm reading from Duncan, a delay of 9 months or more in a misdemeanor assault case gives prima facie merit to a claim of a denial of a constitutional-based right to speedy trial. And then if you look at other cases, that's a triggering mechanism.
But our
So-
most recent case says that
Yeah.
we decline to draw this 9-month line.
The problem with, but this, again, this was 6 months, and we have to look at what the police had. They didn't have anything to go on. But let's say, you don't want to draw a line. You want to leave it wide open. I do think the problem with not drawing a line is it makes it very difficult for police officers, for prosecutors, to kind of triage their cases, prioritize their cases, and courts are to micromanaging the cases that police need to prioritize. Because you don't know what's going on in North College Hill Police Department. It could be a small police department, and they may have some a rash of crime at that point. You don't know, but at some point you have to set a limit. You can't just let a case languish. And I think that's why setting somewhat of a limit, and this court pretty much hinted in those other cases that, I don't think they overruled Duncan, Sears, and Mohamedel in the latest case, but I don't think it was directly overruled. But I think here that it was quite reasonable that, 6 months was not that long of a delay.
Wouldn't the other side of that be, and I understand your argument fully, okay?
Yeah.
wouldn't the other side of that be, when you're looking at the Barker factors and you're looking at the reason for the delay and you're looking at the prejudice, right?
Right.
So the reason of delay could be, everything from, intentional
Could
to,
be.
right? It starts there.
Should
That's like
be.
the most extreme, which
Right.
hopefully never happens, but
Right,
that's
it
where we
could.
begin,
Yeah,
right?
you have to.
So, and then prejudicial, you're looking at situations where the defendant is not able to put on a proper defense.
Right.
So going back to bright line,
Mm-hmm.
it seems like a bright line rule would in effect undermine those two factors, because there could be a situation where the evidence is going to be lost and forever in a short period of time, and that evidence is absolutely and entirely all that is needed for the defense to be able to put on a proper defense. And it opens up, then now we're looking at, the purpose, right?
Right.
So, a person someone who has control of that timing can say, okay, I'm going to lay back, wait for this time to pass.
They could. Mhm.
See what I'm saying?
Well, they
Yeah.
could.
So looking at the other side, I understand the policy behind what you're arguing with regard to the bright line rule.
Right.
But it seems like there's also another side, which would be the policy against the bright line rule.
Right, you could, you gotta, it can be difficult, and then, fortunately, I have a little bit more evidence in this record, and the police literally didn't have anything to go on.
Wasn't
They-
the phone number that they had, it didn't,
And then
he testified that it wasn't his number? or
Right,
something?
and they had his cell phone. And so they, and then it got worse at trial, or at the hearing, at the motion to dismiss, when that wasn't his phone, so they couldn't track him down through his phone.
I would love to, if you can argue the Barker factors.
Well, they couldn't track him down with his phone. His last registered address was 1505, which is a Cottonwood or Collegewood. And he wasn't living there, according to Nina Shaw. The police determined he wasn't living at his registered address. The only description they had to go on after the offense was that it was a dark or a black SUV that he had left in.
How did
So-
they ultimately find him?
That's something, I think it might have been through some traffic stop, but I don't think that, I read this record again this morning because I thought the argument was yesterday, and my short-term memory could be off, but I didn't see exactly. They just said, I think on page 13, I believe it was, that they didn't do anything. I just had it in there until, they didn't have any information until the day of the arrest, is what this record says. But I think it was, and there might be some document that there was some kind of traffic stop where they had noticed the open capias for the initial complaint. And that's what ultimately how he was arrested.
But the thing is, they had a phone number that I guess they were pressed about. Well, you didn't try to call the number, but then didn't. I mean, it turns out that wasn't his number.
Wasn't
right?
his number, and then the other thing is they didn't think calling the number would work because they had his cell phone, so they made the inference that, they probably
That he couldn't
wouldn't
get another
reach
phone.
him anyway, and so they felt they were at a dead end, and they were waiting for a break on the case, and they got one. Unfortunately, it was 6 months, but it doesn't seem that that's terribly unreasonable. And as far as I look at it as showing demonstrable prejudice, the final Barker factor, the video cam, I think, is marginal as far as the probative evidence because they arrived after the incident had occurred. So they could corroborate some of the details of what the victim said happened, but they couldn't really capture the actual offense. It might have shown the victim's demeanor. It may have had some limited value in showing her demeanor. I mean, they could testify to her demeanor, but that, would have been the only thing on there that might have helped or hurt the case, depending on what it had shown. And they suggested in the hearing that due to the retention policy they don't think it's available. They left open the possibility it might, but it didn't sound like it was. They, you know, if you go through the testimony and if they followed the retention policy, it's not, you know. You know, I guess there's a chance, but not a high chance. But again, I don't know how probative that is. You know, it would have been different if maybe it captured the actual offense. And we don't know if that video, you know, it's kind of standard, and we do our best to try to tell police to retain this for as long as possible. But sometimes they do accidentally get lost, and then that's another issue this court's well aware of, whether or not it was in bad faith or
Right.
not, and then we get in that whole
Well,
analysis.
Attorney Springman, I'm going to reserve you 2 minutes. if
Oh,
you
I
like.
thank you pretty
All
much.
right.
Thanks for listening
Thank
to my
you.
arguments. Thank you very much.
Good morning.
Good morning, Your Honors. Laura Peters on behalf of Mr. Benton. As Judge Bach pointed out, this court really need go no further than the State versus Mungie, or Mugney, sorry, thank you, case that was decided 3 months ago, in which this court expressly rejected finding a bright line rule of the 9 months. In the Mugney case, the delay was 8.5 months. And in this case, although Mr. Springman refers to it as 6 months, it was 197 days, which places it actually closer to 7 months than it does 6 months. So,
Ms. Peters, I'm going to read a couple of sentences here. And it seems to me that this case is distinguishable from Mugney. It says, of course, 8.5 months. An 8.5-month delay weighs less heavily in favor of dismissal than a 9-month delay, but we believe that an 8.5-month delay is approaching a year and therefore sufficient to trigger the remainder of the analysis. 6.5 to 7 months is obviously a lot less than 8.5 months. Can you respond to the statement that it's approaching a year? Because I'm not sure that 6.5 to 7 months.
yes, I
Explain your
understand, Your
position
Honor. We would argue, yes, it's still would be considered approaching a year because it's over the 6-month mark.
So should that be our bright line rule, 6 months?
No, Your Honor, I would not advocate for any bright line rule because that would be contrary to what the U.S. Supreme Court in Barker versus Wingo said.
Could it be less than 6 months?
Yes, I would say yes, especially if there was indication that the state was purposely, or the police officers were purposely not serving the warrant to allow certain, these body cam retention policies, they know these.
But I thought that the point is that we don't even get into all of that unless there's a certain period of time that's passed that would make us, I guess, start getting concerned that there's a speedy trial issue. So that issue of purposeful failing to serve a warrant wouldn't even come into play, right? I mean, you got to get through this threshold question.
Yes, I mean, they have called the prong, like the threshold issue, that there has to be a certain amount of delay. And there was also indication that for let's say this was a misdemeanor of the 4th degree, because some domestic violences are the 4th degree. There is case law from either Doggett or Barker Wingo that indicates that, the lower the offense of the crime, the less you should tolerate the delay. So in those circumstances, when you're talking about, no, you shouldn't advocate a 6-month rule because a 4-month rule for an M4 may be more appropriate and under those circumstances. And that's what's important.
How do we determine that?
Based on, because is there sufficient enough to trigger the second, third, and fourth Barker prongs? And in this case, the trial court actually made a finding of prejudice on the first prong. So it's our position that because she makes that finding on the first prong that Mr. Benton was prejudiced, that is sufficient to trigger the analysis of the second, third, and fourth prongs, that there is no prima facie, there is no bright line rule of a 9-month delay. I cited cases in my brief from 2 federal courts, and one was from the Hawaii, where they considered delays of 6 months, triggered the Barker analysis, and so the 2 federal courts did 6 months, and the Hawaii court did 7 months, which is about the same time period we have here. We have 197 days, so we have 6.5 months, almost 7 months. So it's not outside the realm of this wouldn't be totally an outlier for the court to consider the second, third, and fourth prongs.
Isn't there always prejudice with delay? There's always some prejudice.
Correct, Your Honor. There is always some prejudice, but that's why they say, that's why the Barker-Wingo is a balancing test. So if the longer the delay, the heavier that weighs. So admittedly, that's, the 6.5 month, 7 month delay in this case doesn't weigh as heavily as it does in the Magni case.
There's not always actual prejudice that can be shown. I mean, that's why when you have a really ridiculously long delay, even for the fourth prong, courts have been known to just presume that there's prejudice.
Correct.
When you can't actually show it.
Correct.
So you're saying in this case, you were able to show actual prejudice.
Correct.
Which I believe this state is saying, well, no, the body cam really didn't show anything because the domestic or the alleged domestic violence occurred before the officers arrived. So how is that even a proper finding that there was actual prejudice?
Well, first I'd like to point out that the state actually didn't challenge the second, third, and fourth prongs in their brief. So any argument for that on that behalf should be deemed to be waived. So they focused their brief.
Yeah, but you're telling us that we don't need to look at presumptive prejudice. All we need, if there's a finding of actual prejudice, then that will trigger the rest of the analysis.
Correct.
And the state's saying, well, that was improper. There was no actual prejudice.
But in this case, there was, so the concern with the delay is that the defense's ability to present their defense is going to be hampered. And in here, we have the officer testifying he could remember one of the responding officers, he could remember 2 facts. And that was that there was broken glass from a picture frame, and then he looked for Mr. Betton's car for 5 to 10 minutes in North College Hill.
Was there a police report that he did?
Yes, and presumably he would have reviewed that. And yet, when he testified, he was asked what he could recall about this offense, and those are the 2 facts he said he could recall.
Is the written police report on the record? Is that part of the record?
It is not part of the record.
Okay.
So why was the body camera the loss of the body camera footage?
So the body camera footage, yes, it potentially shows the victim's demeanor, whether or not this was, is she really that upset, or is she seems to be giving inconsistent statements, about how things occurred. That would be beneficial for the defendant, of course, obviously, if she starts giving some inconsistent statements about what happened. Because we only have one little rendition of what happened, and that's a written statement, that was in the complaint. The body cam video might also show, is there really any damage to this house? Because she talks about that he came and he, knocked her head into the picture frame. Well, was there anything else? Is there any visible injuries that are seen on the body cam video that would corroborate her story? Or does it indicate where all of a sudden she says, well, I got injured here, and she's in the body cam video saying, oh, I was hit here. So, those are crucial for the defense in order to try and attack the credibility of the prosecuting witness, because this is going to be as a classic he said, she said situation. Would the body cam video, would it have seen the broken glass? Was there blood on the broken glass? Capturing the scene, the demeanor of the witness, whether her statements were consistent throughout. Does she give inconsistent statement at trial? If this would go to trial, is her statement at trial inconsistent with what's in the video? So yes, this was prejudicial to the defendants.
Attorney Peters, I want to bring you back to the state's position of a bright line rule, okay? I assume, and they mentioned Barker and Doggett. So I'm looking at language that's in Barker and Doggett, okay? So the language in Barker, it says, until there is some delay which is presumptively prejudicial, there is no necessity for inquiry into the other factors that go into the balance. And Doggett talks about presumptive prejudice as marks the point at which courts deem the delay unreasonable enough to trigger the Barker inquiry. So that seems to support their position that there should be a bright line rule. How would you address that?
Oh, I would disagree that supports their position that it's a bright line rule. It just talks about that there has to be some period of delay. Because in the Ohio Supreme Court talks about, they indicated, you know, and Doggett set that 1 year. And in the Ohio Supreme Court, when they were looking at it for a felony case and State versus Salvage, they said a 10-month, delay was prejudicial. So the Ohio Supreme Court has already signaled, no, there's no bright line rule here. This court in Sears indicated, it actually started indicating that because this was a speedy trial is 90 days, we should really look to see if our starting point is 90 days. Has 90 days passed?
Are there any other cases that you found, whether it's in Ohio or anywhere, that say that if a court finds actual prejudice, then that would trigger the analysis of the remaining Barker factors?
The one case in, hold on. This one case I cited, U.S. v. Simmons, it said noting a 6-month delay on 2 counts of forgery was a borderline case, but held that it was sufficient to trigger the Barker inquiry.
But
I
that
don't know
wasn't a
that they actually
finding,
said it
that
was-
was 6 months, but it wasn't a finding of actual prejudice. Because it sounds like that's what you're asking us to do, is say, well, because this judge found actual prejudice, then that would be a trigger.
Well, right, but, I mean, so yes, because there was a finding of actual prejudice, that should trigger it. And under these circumstances, 7 months is not, and when you consider that the police made no effort to locate Mr. Benton.
But Ms. Peters, to Judge Krause's point, did the trial court misapply the law? Because if she found that there was no presumptive prejudice, which she did,
But then she follows quickly up and says, but I find that there was prejudice.
right, so did she misapply the law of Barker?
No, she says, I understand, she goes, I understand this factor, and I'm going to find that there's prejudice. So,
But how could she have gotten to prejudice if there's no presumptive prejudice?
well, I think maybe she was looking at that night, because the state was arguing below for the 9 months, and that's the presumptive prejudice. And so she's like, well, right, I can't meet the 9-month rule because this is only almost 7 months. But in this case, there was actual prejudice. So, I mean, I would say that finding an actual prejudice should trump having to find any presumptive prejudice. Because obviously, the trial court has looked at all the evidence presented to it and has found that Mr. Benton's speedy trial rights have been violated because they didn't they didn't pursue these charges against him for almost a 7-month period.
But isn't the whole point of the presumptive prejudice triggering factors because, we're looking at a Sixth Amendment constitutional speedy trial violation, and we have to say whether or not a certain amount of delay is long enough to potentially even rise to a constitutional violation. I mean, you could have actual prejudice, in 2 months.
True.
Yeah.
But in this case, again, this is over 6 months. So when you're talking about that if they had arrested him immediately, they had 90 days. So that 90-day period expired twice before this case was even begun. So when you're looking at it like that, then, yeah, that seems to indicate that that the delay does cause some constitutional concern in this case. If there's no further questions, we would ask that this court affirm the trial court. Thank you.
Thank you.
Can you please, the court, I was just going to, you had just touched on it, but one of the notes I wanted to make is I don't think I emphasized enough the trial court did make a finding that there was not presumptive prejudice, and I think that carries some weight. The other thing is,
And then looking at I've wondered if she was meaning what she said, if you know what I mean.
Yeah, I do. Yeah, I because she went through
Because of the
analysis,
exactly.
and so that was part of it. Is the judge we didn't think was following the law. That was part of the appeal, because then she went into the analysis, even though she didn't find that there was presumptive prejudice in the delay, and there is no evidence that the state really used any bad faith here and tried to sit on this case. And then
Would you, and I don't see evidence of bad faith, but
Right.
would you consider that it negligent?
Well, that's difficult because, again, I think that's hard for courts and for us to analyze. And the difficulty I have just in practical experience is police are going to call and ask us these questions, and it's good to give them guidance. And so if a police department says, I mean, they got so many cases, they have to triage it. If we say, well, you only got 1 month, we only got 2 months to get to this case, that can be very difficult, and that involves courts kind of micromanaging, again, the police departments and how they handle cases, how they triage cases, and what order they put them. So we have to, I would argue or urge the court to give police some flexibility. On the other hand, I completely understand we have that Sixth Amendment speedy trial right under Barker versus Wingo. It can't be unreasonable, and we've sort of got some case law that sets out some guidelines of when there's this presumption of prejudice and the length of delay. And so the guidelines seem to be, and it's not a hard and fast rule. I mean, our district here is kind of given us a little bit of a guideline of 9 months, and the other case was 8.5 months because it was a little bit different than
Can you
this.
talk to what it is that the court has traditionally considered in determining that period of delay that then kicks in and then you go into the Barker factors? Because it's not just the timing.
Yeah, the Seventh District thought that not even a year was close enough. That's the Seventh. But then you look at the First, and it seems like most of the cases, starting with Sears, then Duncan and Mohamedel, those were 21 cases. One was decided in March, one was September. And so those suggested 9 months was what would trigger the analysis under the remaining Barker
Didn't the
factors.
courts look at things like what was the severity of the charge, what was at stake?
Right, and so on Mohamedel, it was like this case, it was a misdemeanor assault. It wasn't domestic violence, but it was still very similar in a misdemeanor assault, and the court put that at 9 months. So Mohamedel is the case that's the closest to this, and this court suggested it was about 9 months is the triggering threshold of when you go through the remaining 3 Barker factors. But I can understand also having, an exception if you have a situation where the police acted in bad faith or sat on a case purposely for whatever reason. It might be hard to prove, especially in a 6 months or the lower time frame you get, because again, they have to try to prioritize.
Well, particularly,
their
for
cases.
example, if you have scientific evidence that's only retained for a very specific amount of time, and that scientific evidence is determinative.
Well, let's say this case went forward, then I think there would have to be some, motion could be filed, and maybe the court would find that that is something that's prejudicial. But but again, here that seems hard to do. I don't know what more the police could have done. I don't know what the body camera footage would have shown because, it's not a he said, she said, because the two responding police officers could have testified to the demeanor of the victim. They could have,
Well, how do you
testified
address
beyond.
the argument that the Barker factors were not argued within the brief?
Yeah, I didn't argue them in the brief because we didn't really, we spent a little time on them at trial, but I think our whole purpose of bringing this appeal was, since the trial court made a presumption that this wasn't prejudicial delay, the analysis should have ended. And that's what we are trying to, convey, maybe, that that's the law, because that was the understanding of the law that we had from the cases decided by this court, that once there is no presumption of prejudicial delay, you don't go on like the trial court did here and analyze the three Barker factors. So that's why we're saying the
And
court
that would
erred
be
as a matter
based
of
then on
law.
only one reading of the transcript then?
Right. And you could find, yeah, right.
Okay.
And I think I can't understate more that there was that finding by the trial court of this was not presumptively prejudicial. I think that was the finding, and it should have ended there. And that's kind of the whole basis of the appeal.
Thank you.
But thank you. Thanks for listening to my arguments.
All right.
Thank you.
All right, thank you so much. Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. Thank you again, and have a wonderful week.